If you own a rental property in Washington, D.C., you've probably seen the headlines. The DC Council passed the Rental Act of 2025. You heard eviction notices were shortened. You heard non-payment notices dropped from 30 days to 10 days. And you probably thought, finally, evictions are fixed. Today, I want to give you a reality check. Because while the notice period changed, the core system did not. And there's a massive difference between what the law says on paper and what actually happens in the landlord-tenant court. This is not legal advice. This is operational reality. Here's what most owners believe. They believe that a 10-day notice means a fast eviction. But here's what the numbers show. In fiscal year 2025, despite thousands of eviction filing, only 1,400 evictions were actually completed citywide. That's not because owners didn't file, it's because the system is still backlogged. So today I'm going to walk you through the real timeline from the first missed payment to US Marshal at the door. Let's start with the good news. The Rental Act did not change notice requirements. First, dangerous or violent conduct. If a tenant commits a qualifying dangerous or violent act, the law now allows a 10-day notice to vacate with access to an expedited hearing process. That is a real change. Second, non-payment of rent. For standard non-payment cases, the pre-filing notice period was reduced from 30 days to 10 days. That means you can file sooner. But filing sooner does not mean finishing sooner. Here's where expectations break. Even with a 10-day notice, your case will enter a same landlord-tenant court queues. And the court's still prioritizing older cases, diversion eligibility cases, sealed record proceedings, pandemic-era backlog matters. As a result, owners are still waiting weeks just to get first hearing date. Then more time for continuance, then more time for compliance periods, then more time for marshal scheduling. Shorter notice, same slow system. Now let's step away from emotion and talk numbers, because this is where good operators separate themselves. Here's a conservative comparison. Legal eviction route, $2,000 in legal fees, 7 months of lost rent, at $2,000 per month, that's roughly $16,000 before you regain possession. Now, compare that to a buyout. Offer the tenant $5,000 to vacate within 14 days. Many owners resist that. They say, I shouldn't have to pay them. And you're right. But the question is, what should happen? The question is, do you want to be right or do you want to be profitable? The math answers that for you. There's another major change owners need to understand. As of 2025, eviction filings are sealed until a judgment is entered. That means you can no longer rely on simple court search to see if a prospective tenant was sued last month. Many cases never become public. This forced smarter screening. Landlord reference matters more. Payment history matters more. Verification matters more. Court scrubbing alone is no longer enough. The reality check? Here's the honest takeaway. The Rental Act adjusted notices. It did not fix the courts. Evictions are still slow, still expensive, still uncertain. That doesn't mean you do nothing. It means you make decisions based on time, cash flow, and risk, not headlines. Every building is different. Every tenant situation is different. Nothing in this video is legal advice. But if you're a DC multi-unit owner, you need to understand how the system actually behaves. That's why I share tools, calendars, and real-world decision frameworks inside our private DC multi-unit landlord group. No noise, no theory, just owners comparing notes on what works right now. The link is below.